Hello everyone, welcome back to my YouTube channel. As guys, we have started the lecture series on Hindu law for Bihar Judiciary. As all of you know that Bihar prelims exam is on 7th of October 2020. So we have started the revision of Hindu law, and this may be the crack course for Hindu law. So, here again, I am with you with a new discussion on this lecture series. So, yesterday we have discussed the conditions of Hindu marriage and the violation of those conditions and what happens if those conditions are violated and what are the consequences of the violation of those conditions which are mentioned under section 5 of Hindu Marriage Act. So again, in the form of revision, we'll discuss the next some sections. Okay, before going further in the discussion of next lecture series, firstly we shall revise what we have discussed till now. Okay, so guys, we have discussed section 5 and the conditions which are mentioned in section 5. So what are the conditions? Those conditions are first was monogamy, second not suffering from mental disorder, third condition was of age, and fourth parties not to be within the degree of prohibited relationship, and fifth parties not to be superior to each other. So for the violation of these sections we have read the sections relating to punishment for the violation of these conditions, and these are sections 11 and 17 for monogamy, and section 12(1)(b) for not suffering from mental disorder, and section 18A which mentioned about 2-year rigorous imprisonment and 1 lakh rupees fine for age, and next section 18B for the section 4 which mentioned about degree of prohibited relationship, and 18B provides about 1 month jail or 1000 rupees fine, and sections 11 and 18B for section 5 or condition number 5 which is mentioned in section 5. So we have discussed all of these in the previous video, but the point to note is that from when the factor of age or the condition of age is changed from 18 to 15 to 21 to 18 years, like before 1978 the age was 18 years and 15 years, but after 1978 or from the 1978 onwards it changed into 21 years and 18 years, 21 years for bridegroom and 18 years for bride. So under the next from year 2007 onwards it was substituted that the imprisonment will be of 2 years rigorous imprisonment and 1 lakh rupees fine or both. So basically here the point to note is that from which year this section about punishment was substituted. So this was substituted from the year 2007 onwards, and it is also the point to note that from when the section 6 of subsection 6 of section 5 was omitted. So it was omitted by 1978, year 1978, And it is also to be note that what is the case related to section 5. So important case which is related to section 5 is Valsama Paul versus Cochin University 1996. So what was held in this particular case? In this case, the court held that if the conditions laid down in section 5 are fulfilled, only then the marriage is valid. And also interesting point in this case was that the prior permission of parents is not mandatory for marriage, for a Hindu marriage. So there is no need to take permission before the marriage. It was the case of Balsama Paul versus Cochin University. So this is the point to be keep in your mind. Next, guys, we shall discuss the next provisions of Hindu Marriage Act. So let's discuss today section number 6. So what says section 6? Section 6 is about guardianship in marriage. So it was also omitted. It is also omitted. And from the main point to note is that from when this is omitted. So this section number 6 is omitted from the year 1978. Next is section number 7. So now discuss the section number 7. Let's discuss it. So section number 7, it is about the ceremonies for a Hindu marriage. So guys, you will have to keep in your mind that ceremonies of Hindu marriage are given in section number 7, and which it also says Saptapadi. So if it is asked in your examination that in which section Saptapadi is given, so this is given in section number 7. What says it? It says that a Hindu marriage should be solemnized according to customary rites, number 1, and number 2, ceremonies of either party. Second, when such rites and ceremonies are to be held, then the Saptapadi is the main essential point. So basically, what does it mean by the Saptapadi term? Saptapadi is the steps which are 7 steps. So 7 steps by the bridegroom and the bride jointly before the sacred fire. When these 7 steps are taken by the bridegroom and bride jointly before the sacred fire, only then the marriage will become complete and binding. So when the 7th step is taken, from the moment onwards the marriage will become binding on the parties, on both of the parties, on both of the husband and wife. So basically the Saptapadi ceremony is important in this section, and Saptapadi is all about 7 steps before the sacred fire. So we have discussed here section number 6 and section number 7. Now which case is important for this particular section from examination point of view? So this case is Ram Awadh versus Krishnanand. Ram Awadh versus Krishnanand 1981. So in this case it is held that Saptapadi is an Arya Samaj system. Saptapadi is taken from the system of Arya Samaj. So also a point to be noted is that in Arya Samaj system 14 steps are taken, 14 feras, and in traditional system 7 feras or 7 steps before sacred fire. So according to traditions and according to Hindu Marriage Act, Saptapadi is essential, Saptapadi is mandatory for the marriage. Okay, now we have discussed section number 6 and 7. At section number 6 is omitted. and section number 7 provides about the ceremonies for Hindu marriage. Now what about the section number 8? So section 8 is all about the registration of Hindu marriages. So what will be the procedure for registration? Subsection number 1 says that state government may make rules. State government may make rules for the registration of Hindu marriages, and this particular registration will be subject to conditions which are mentioned in Hindu marriage register and which is kept in the Hindu marriage register. Second essential point of this particular section is that if this section is violated, if the provisions of this sections are violated, means if the marriage is not being registered, then what will happen? So on the violation of this particular section, there is the provision of punishment. So in the old act, this punishment is given to that it may be extended to 25 rupees, but now this is 1000 rupees. So this is about the registration of Hindu marriages. These points are only to be noted, that who will make the rules for the registration of Hindu marriage. So that is central government, that is state government, that is district government, local government, that is, or both of the central government or state government. So here the answer will be the state government. Okay, so registrations, what is the case on this particular topic, registration? So the case is Seema versus Ashwini Kumar, 2006. Seema versus Ashwini Kumar, 2006. In this case, it was held that registration is mandatory for Hindu marriages. So we have discussed section number 7 and 8 in this particular video. I hope you all understood this particular topic, this particular concept for your examinations importance. So in the next video, we will discuss the next provisions of Hindu Marriage Act, which are also essential and also beneficial for your partner, for your upcoming Bihar Judiciary exam and so on judiciary exams. So I hope you all got it. So now meet in the next videos, guys. Bye, and thank you so much for watching this particular video.